Okay. It says I'm live again. Oof. Uh-oh. Uh-oh. Let's see. Righty. Bolin, come help me. Damn it. Okay. Okay. Oh my goodness. Is that working? Come on. Come on, come on. There we go. Woo! Always with the technical difficulties. Oh, y'all, I am a mess today. I'm so sorry. I am moving offices, like just from one office to like another down the hallway that's bigger. So I've been at the office since 7 a.m. just moving shit. So that's why I'm all gross looking. I'm sorry. I'm so sorry. I'm gross. Oh, vey. Oh my god. I had just a week. I just had a week. Did everyone have a week? I am Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, and you are watching Cadillac Law. It is our Friday weekly update, and boy, was this week exciting! I'm telling you guys, I had a week. I have had a week. Get in these comments. Oh, guess what? We're remonetized. We're remonetized. Yay! Yay! So we're going to update that background. Good morning, Deidre. Thank you for joining us. So I had 3 months of punishment, and I'm not going to lie, it was kind of a nice 3-month break. But I was demonetized, and so everyone that supported me through Cashapp, I really greatly appreciate you. That was wonderful. Everyone who's like, where'd the membership go? It's going to come back. Everything is coming back. You can do super chats again. You can do all that stuff. Yay. What a week. We had a very cold spell here in Dallas. I'm talking cold. And it even snowed on Wednesday. And if you know anything about me, you know I don't be driving in the snow. No, 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 no. So I had to cancel my Wednesday hearings, but then, oh my God, we just had, just the whole week was So much. It was a whole week. It was a week. Okay, so we spent Tuesday evening together watching the APRocky verdict. This is the verdict I predicted. This is the verdict you get when you bring charges against someone that and don't have any evidence to support those charges. This is the verdict you get when you when you're a jerk. You're an absolute jerk of a prosecutor. This is what you get. This is what you get. I don't think the jury enjoyed at all the prosecutor or his style. I don't think they liked Joe Tapioca either, but they definitely saw that there's no damn evidence. There was no evidence. There certainly was not evidence beyond a reasonable doubt. I mean, come on, guys. All right, so this was my watching it live. They reached a verdict. They all, this was really weird. Typically, the jury reads the verdict and then the judge verifies with each juror that that is in fact their verdict. So it was very weird to have the judge verify that it was their verdict and then hear the verdict. All right, so I don't want copyright issues, so we'll just skip right ahead. Here's Joe Tapioca and Rocky hugging each other. This is very exciting. Not guilty. Not guilty. As he should have been found, because straight up, we know he shot some kind of gun. There's no evidence that the gun had like a real bullet or did any kind of damage even to the cement. And those knuckle scrapes, y'all. Oh my God, if I was a juror, I would be so irritated. You scraped your knuckles. Okay, so we're gonna go now to, so that's the big Rocky update. That's exciting. I also heard that Rocky and Rihanna promised to name their next son Joe after Tapioca. So that's cute. If anyone wants to name their daughter Lauren or son, please feel free. It is the best name actually ever. So, okay, so Melly, Melly is next level confusing. Okay, Deidre, it is not you. You are not alone. All right. He had a trial. There was a hung jury. Then there's a new trial was set. The defense did a motion to exclude particular evidence. The judge ruled in their favor. The prosecution appealed that ruling, and it's my understanding that ruling is still under appeal. In the meantime, Melly himself has been charged with witness tampering, and his lawyer, Raven Liberty, this gal, is under investigation for the same witness tampering charges. Hey, Frederick, good to see you. Welcome. So, Raven Liberty, the state government got a warrant to search her Apple iCloud to see if they can prosecute her for witness tampering. It's a whole mess. This prosecution's a mess. So there have been a gazillion motions and trials, and the defense is adamant that they need more information about the Raven Liberty investigation in order to determine if there truly is a conflict of interest in the representation of Melly. And that's true. And I think it was last week or the week before, the judge basically refused to do his job and would not look in or inquire into the potential for the conflict, which is really quite upsetting. In this hearing, it seems that the judge kind of backtracks. So let's get to it. We'll watch it together. It's kind of weird, but it's also hard to hear at times. Now, mind you, Melly has been in jail for 6 years, and he is technically innocent because you're innocent until proven guilty. So we've been jailing a man for 6 years who has not been proven guilty, an innocent man. Hi, so glad. I'm so glad you made it.
Okay, I'm gonna go back on the record. This is on top of my page 3. State versus Vermont. That's 1972 C10A. I've got Ms. Collins, Mr. Griffiths present for the state. I've got Ms. Liberty, Mr. Adelstein, Mr. Aaron, and Mr. Benjamin. Present for Mr. Devon, and likewise is present. So today was on all pending motions based on our last discussion. The last time we were all here, I had asked that you decide to set new notice of hearing for what motion you want to be here. The only notice of hearing that I can find that was filed by Ms. Liberty, February 8, 2025. It raised 8 motions. Number 1, defendant's motion for order to show cause. The state of Florida's ongoing willful and flagrant violation of court dated February 9, 2024. 2, motion limited to exclude James Howard the relevant and material detention communication calls. 3, motion limited to exclude a relevant and immaterial TikTok video of meat page. 4, renewed motion to take deposition of Christine Bradley. 5, defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. 6, motion for scheduling order. 7, amended third motion to compel forensic images of the proceedings following. And 8, motion to compel. So that's what I wanted to get done today. State, I'm being told that there's a medical issue with Ms. Buckley. Is that correct?
That's correct.
Okay, she's on that level. And what's your position as far as what you want me to do today?
So the other issue we have, and I wasn't present for the hearing Friday afternoon, but my understanding was the court set a notice of hearing deadline for Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stopping court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing was properly filed and there's nothing to be heard today.
Okay, so last week, the judge had made this deadline for all these filings. And literally, they had to like go from their hearing straight to go write all the motions and file the notice. Dude is being a total prick. Okay, she filed everything by Friday. She just didn't send the notice of hearing until Saturday morning. Like, get over it. She's a mother. She has a life. She needs to sleep. She's a human being. So that is now the prosecution's being super picky.
So you want to do anything?
This also might impact the trial about that.
Defense, is everyone you want me to do?
The funny thing is, the great thing about those cameras in this room is everything is recorded. I did say Friday at 9, and then I actually stepped back because I knew I was setting myself up for failure. And I said, well, I do it Saturday. Taylor then responds, oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention, because last night in preparation of this, I know the last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they've filed several different motions saying it doesn't matter what case numbers are on the motions because these discoveries interchangeable, quoting exactly the language from their own motion.
So, the state is saying, oh, well, she can't do that. It needs to be under this case. But then on the other hand, they're talking about both sides of their mouth. We can file it under any case. It's interchangeable. These are great points.
Okay. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward. There are 2 state attorneys sitting over there. Understandable. One of them is missing. Mr. Griffiths, is there something funny?
Nothing you don't want.
She is on a roll this morning. She is not happy.
Ms. Liberty, you can direct the comments.
Okay.
All right,
So we're ready.
Judges don't like it when lawyers talk to each other. Like, we're not supposed to do that. Don't look at him as something funny. You say, Judge, is there something funny? Is there a reason he's laughing?
Here to talk to each other about this.
We're ready to go
Start.
for it, Judge.
Okay. Listen, State, I get what's going on. I'm not going to put anyone else done here, but I read all this and I went through the entire court file preparation for the hearing today. Most of these are fairly straightforward. Over your objection, I'm going to hear them. But if we get to some specific factual issue that you say, only Ms. Buckley has the particular knowledge to address, you can certainly tell me that. But again, I find most of these to be very straightforward. And I think you probably would. So that's over the state's objection. So.
Yeah, you've had these shits on file. These pleadings and these motions have been on file for over a year. That's plenty of notice. Okay.
Listen, let me just do them in the order. That they're noticed. So number one is defendant's motion for order to show cause by the state court should not be found to be kept for ongoing willful and flagrant violation of court order dated February 9th, 2024. I did read the motion on all of these. I read all the motions. If there wasn't any authority cited therein, I did review that as well. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9th, 2024, nor any order that you referenced on a motion for rehearing February 16th, 2024. So if someone could show me those two orders.
The other one is just, I think I may have
That's a whole damn year ago, y'all.
made that motion, that you see an order from the homicide, they take the appeal, and I believe it was late December, so then you see orders coming from the tampering case, so that might be where the confusion lies, is there was two motions for rehearing. I filed the motions to compel, we came into court, the court had ordered that they comply with it, they filed a motion for rehearing. If you want, I can pull it up on the tampering case, because more than likely where it came from.
Is that what it is? I mean, I can pull it up. You tell me it's not in 1972.
Yeah, that's kind of why initially I had this filed under 2023, because it would be easier for the court to file. The state objected, wanted everything filed under 2019.
She's like full of sass today. So there's an issue in that the state filed charges against Melly in 19. So they have one cause number for the unaliving of his friends. Then the state is now accusing him of tampering with witnesses, and they filed those charges in 2023. So now there's two cases, and they have different case numbers, and so some orders are done under 23, some are done under 19, and it's a big fat mess.
Or we could take that one honest, and I'll take a break and then pull everything up so it's there.
No, give me a second.
So the next one would be James Howard, phone calls.
Yeah, number two is defendant Jamel Demon's motion let me to exclude James Howard's irrelevant and immaterial retention communications. So you're talking about, this is a motion let me for trial. When I read the motion, anything else you want to tell me in support of your motion?
This judge, it was to, I want to say 84 hours worth of phone calls that were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, it starts referencing a investigation that's being done by Danny Polo into this James Howard, and I believe the Alden game. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then there's James Howard telling somebody on the phone call that he has to do something from Melly that day. We had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over 80 hours worth of phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, oh, I have to talk to Melly today. Not I have to do something for him, not I got to call people for him, nothing at all. During the deposition of Detective Polo, when I started questioning him, hey, I went through all these phone calls, could you please direct me to what phone call I should be looking at? What batch of phone calls? He then tells me, it's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering, I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Polo, in his own words, was the only time that he has heard James Howard talking about Melly, would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Dave, can you respond?
Yeah, like before we proceed on that, there is still the outstanding issue of whether Mr. Dennis wants to study about the beginning time, the state to raise the issue for the conflict of interest. The court pointed that out. That was going to be one of the first things we were going to address today, and we still need to address that because obviously if he does not want to consider representing him, then there's an issue to that with the party.
I mean, that's his call. I already had that discussion. So I'm sure if there's something that you want to let me know, you're going to let me know. Any response to the motion?
Yes, Judge.
State being a big pussy. Oh, well, she should have been. Obviously, Melly wants her there because she's there making arguments. So, also, none of your business, state. They're really trying to get her disqualified.
They filed a written response to leave yesterday. This is one that's properly prepared, but as pointed out in the argument, the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on responses.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing off because they wanted to continue it because they didn't get proper notice. A notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me. I could give you
She's pissed.
a lot of adjectives about what I think of this entire procedure. Funny is not going to be one. So, anything else you want to tell me about this?
No, Judge, I would say that there are no material phone calls that would even go to the nexus of witness number.
Okay, so, this one, and I'll enter the appropriate order to be denied without prejudice. I have no idea what is or what is not going to be relevant. And without getting the evidence at trial, there's no way that I could. I can't make the state try to take some vacuum. But just without prejudice, you can certainly raise the issue. If the state tries to introduce any of these phone calls at trial, make the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be in the trial. So that one's going to be denied without prejudice.
So, Judge, I had, for the sake of the court's time, emailed and asked your chambers how you wanted to proceed with some of these videos. So the next one would be a TikTok video. We can show it, or I can give it to chambers. That's what I didn't know going through the past. We usually have provided it, and then you watched it.
Well, listen, I'll let you argue what you want, and I'll let the state respond as they want, but for all of these, it would be the same thing. I don't know what the evidence will be in the trial. There's actually already been a trial, and the evidence may be the same as the first trial, or it may be completely different. I have no idea. But I can't make a decision now without there being one witness, without being one piece of evidence, without hearing the answer of one question in anyone's testimony. You may be right. These things may be not relevant, and the state may not even try to introduce them. But I can't give you a pretrial ruling, again, in a vacuum when I haven't heard.
Okay, so the judge is basically saying, I can't exclude this evidence without having more information about all the evidence and seeing the moving parts, which I kind of don't like. You know, you can exclude evidence as a judge. There are motions to eliminate. That is something that is possible. So I think he's just trying to pussyfoot around, and I don't like that.
So how would you, I'm just curious, how should we proceed? Because we
Yeah, exactly.
We are seeking for pre-trial rulings to keep out certain evidence that's not relevant. So the next one on here would be a TikTok video, period. We're dealing with i.e. homicide. This video is after the homicide. I don't even believe the individual in the video, which would be, and excuse me, I'm going to see her name, Geneva Molina, doesn't even know Mr. Dennis. So there is no relevancy to the homicide and my client. If it was filed, I guess, because they have it interchangeably with the tampering, there is no, I guess the tampering in this case would be Mariah Hamilton. There is no evidence in that video of Mariah Hamilton. There is no evidence in that video of anything, period, that has to do with this tampering case or this homicide case. I believe it is the state's burden at this juncture, not our juncture. It's not relevant, period.
I don't agree with you. It's not the state's burden. This isn't the trial. So, state, anything you want to tell me?
No, we would ask judges to defer ruling depending on whether or not it comes out of the trial. Depending on the evidence, it may become relevant once I provide it, and we can't tell you this time. And we can't say we don't find it defense, and should it become relevant trial, it will be subject to all appropriate relevancy objections, and we can address it then.
Thank you. So, for this one, I'll enter a written order. Again, the defense motion is denied without prejudice. Certainly, you can bring up whatever appropriate objection you need to at whatever time you feel you need to, if in fact the state ever tries to introduce it at trial, which maybe they will.
I don't like that. I don't like
So
that.
I'm following the court's ruling, and if it comes to the trial, should I then file a renewed motion eliminating, so it can be argued in trial, or will it just be readdressed at trial? All right.
Number 4, renewed motion to take the deposition of Christine Bradley. I did read the motion. Anything else you want to know?
I would just say Judge Murphy had already mentioned that word, which I attached, number 18. And it says, after such emails are reviewed, if the defense still wishes to depose ASA Bradley, counsel shall file a written motion. So I did that, I did sometime in February, close to a year ago. I wrote it out. At this point, we need to depose her, especially in light of all the things that I went through, and I amended this motion to add a few other things that have happened in the deposition, i.e. these emails.
Okay, so Bradley was the first prosecutor, the one that did the first trial. She's been withdrawn. There's been a lot of dirt on her, and now they want to depose her.
They did even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that clearly state it's official proceedings. They don't prove it. I know that. I did the deposition of Garrett Steele. He can't even tell us what a subpoena is. He kept saying that's a lawyer word. When I asked him under the statute, tell me what official proceeding is. He goes outside of the statute and tells you anything that's involved with a lawyer, that's an official proceeding. That's your lead detective. They want to kill my client. That's what we're playing with his life.
Stop, wait. You just saying this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Liz
like
Bradley's testimony in the murder case is fully irrelevant, so.
they want
Let's go
like
back. We're talking about the tampering case, we're talking about the.
we are talking about
homicide
the
case.
tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got it. Respectfully, over to the defense objection, the renewed motion to take the deposition petition of Travis and so I'll get the appropriate written order. I don't find that her testimony would be relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's been followed with the tampering case, information or what's required to prove them.
Okay, so the government's getting everything they want from this judge, which is really annoying, but okay. Yeah, this judge does not want to do his job at all.
I think the court ruled that since defense counsel has not been charged or defended in the case, and they've had this information for over a year.
Okay, so now we're coming back to the fact that Raven Liberty is being investigated and the potential conflict.
Nothing's been done. That it does not qualify as an ongoing investigation. In addition to that, that they are obligated and they cannot hide behind the open investigation provision when it deals with information on charges against Mr. Dennis, specifically the murder and the tampering. And they've indicated that the tampering case is somewhat going to be used in the murder case, as I think they said, consciousness of guilt. Furthermore, I know the court has told us to talk to Mr. Dennis concerning the potential conflict, and they have alluded to the conflict today. He doesn't know how to make that decision because he doesn't have sufficient information to determine whether or not he wants to keep Miss Liberty or any of us on the case because of this pending, so-called pending investigation. I mean, it's now over a year. It's more like 14 months that they've sat on this information.
So, State, listen, for the most part, I agree with what Mr. Davidson just said. You have a continuing obligation, so when you agree anything that comes from any source that is relevant to the charges against Mr. Dennis, you have to turn that over, right?
Before we, yes, sir, there's his ongoing obligation for things relevant to his homicide or to his open tampering charge that would be turned over. Having said that, Judge, we weren't noticed for this particular motion today. We would rather have a full response. The notice said motion to compel. We didn't actually receive this with Miss Liberty's pleadings. This one actually came separately, and we only received it, I think it was 2 days ago.
214 that was filed.
And honestly, it says motion to compel. Miss Liberty's filed so many that we were unaware that this was going to be argued today.
Get out of here.
Hold on. Here's the last paragraph. Here's what Mr. Davidson said. Affidavits, search warrants, police reports, the name of any witnesses, and all witness statements related to the Apple iCloud account belonging to Raven. Before I ask you anything, all this stuff belongs to Miss Liberty. Does she ask Apple to just give her a copy?
I believe her lawyer did write a letter asking for the return of all, and they said they would give you nothing.
They're not going to give her her own thing?
Nothing.
So let me just, if you
You
want,
asked for it,
I
they told you no.
did actually email, because when they let me know about before, they give you an email that you can address to them. So I sent them an email. They said, hey, we told you, you have to contact your Broward Sheriff's Office to get anything done. So
Apple won't give you your own stuff?
They said Broward Sheriff's Office. Apple then did sit with me. I went through it. I have access to the iCloud. They will not give me the return of what they.
If y'all have Apple, you need to switch. Apple is bullshit. They won't give her her own things. Like, what? They don't even fight the subpoena. They don't even argue. They just hand the shit over. Get off Apple, y'all. I am a Android user through and through. I prefer security. I prefer a company that's going to fight the government. Thank you. They won't give her her own stuff. It's just wild.
Yeah. But you have access to the iCloud and that's all your stuff on it.
Of course,
Yeah, but how the fuck's she going to know what they are looking at?
that's just my iCloud.
Looking at
It doesn't matter. They have it in their
No,
possession.
listen, I don't disagree with you, but you all are a little more adroit in these technical there's nothing that's outside of what's in her iCloud. Everything's in it.
I don't know. I don't know what they see, because I believe there are additional search warrants based upon the original search warrant.
Well, I don't know anything about that, but as
I
far as the
understand.
search warrant, I already ordered you to get that, you got it. As far as police reports, there isn't any police reports, right?
It's still no, it's still no investigation, Judge. That's all.
Well, I disagree with that pursuant to Florida statute, but there are no police reports.
There are no police
Because nothing's happened. Okay, so there's no police reports. The names of any witnesses and all witness statements related to the Apple iCloud, that would be like a custodian of records, right?
That would
There's
be-
no other witnesses to iCloud, except a custodian of records.
It would be Apple or the records custodian certification.
Have you listed a custodian of records?
There's nobody to know, Your Honor. We have not listed
Not.
either the homicide or the tampering case.
So you would have an ongoing obligation to do that.
We
We have
have-
wanted to use any of this.
We have an ongoing obligation to turn over anything that's relevant or may be relevant to either of those two cases. We are complying with our discovery obligations at this time.
All right, so affidavit, that would be, a defendant would be entitled to the affidavit, for example, if they wanted to file a Frank's motion, if they wanted to say that this was incorrect and the judge should have signed it. But Mr. Demings doesn't have standing to raise any of that. That would belong to Ms. Liberty. It's her stuff. There's no case involved, so I don't think at this point you tell the affidavit, but this is what I'm gonna do. Go ahead, sir. I'll give you the
I find it hard to believe that there are no investigative police reports saying they contacted witness A, witness B to verify or to corroborate whatever is on, whatever they seized pursuant to their original search warrant. I find that hard to believe that
Me
in
too.
a year, they come in here and file a motion indicating that Ms. Liberty must get off the case because of the conflict. I find that very hard to believe.
Uh-huh.
And I find it hard to believe that they, in their investigation, did not take statements of potential witnesses.
Agreed.
And they say it's interrelated to the murder and tampering case. So
Well, I mean, they're in a continuing obligation, okay? If we get somewhere down the line and something is put before me that they had material that is required to be disclosed pursuant to 3.220 on February 18th, and sometime long before February 18th, and Mr. Griffith is standing here and telling me otherwise, he's gonna have a very large problem, right? A very large problem. So I'm not playing with it.
And I appreciate it.
So at this point, I have to take everything at face value.
And
With that being said, I'm gonna grant your motion in part as follows. State, I'm gonna give you 20 days to turn over anything that you have received regarding the Apple iCloud of Brave Liberty that you intend to use at either trial, okay? And make it as detailed as you can, because if we get forward to the point of a trial, and they stand up and say, Judge, they didn't disclose this, and now they're trying to use it, you will not be using it. It will be barred as evidence at trial, okay?
Okay, that is a fair ruling. You got 20 days, cough it up. That's perfectly fair. So, Frederick, I watched the whole first trial and I was not convinced. But also, you know, I wasn't, I don't know, it's hard to say what happened, right? It was really difficult to determine that. I know that Melly is being completely isolated, and they've had him just on his own, solitary confinement. My understanding, he's in a place where there are no other inmates at all, and that is terrible. That is something that will break someone's psyche and someone's mind. I do notice that he's gotten a bit more from years ago to now, and again, you know, that's what solitary confinement does to you. Tall glass, this judge does remind me of Glanville in that he doesn't want to make a ruling, but here he finally made a ruling, said, okay, you guys got 20 days, cough it up.
So that's 20 days to turn over anything in the Apple iCloud, download, that you expect to use at trial in either case in Mr. Dennis' case. All right, and I'm basically ordering you to comply with the rules, which you already should be complying with, so.
With that,
Otherwise, the defendant's motion otherwise respectfully is denied for the reasons that I stated on the record. At this point, there being no arrest and no charges and no case, I don't believe that there are any police reports. I don't believe she's entitled to the affidavit, and outside of records custodian, I don't believe that there's any witnesses or witness statements. But again, if that turns out to be something different somewhere down the line, I'll address that.
what about the affidavits?
I don't think you're entitled to.
If it's not a pending open investigation,
Then-
and they're alleging certain things that supposedly deal with the tampering and or the murder case, then we're entitled to that.
Well, he has to turn that over.
Okay.
Whether it's in the
Okay.
affidavit or not, whatever it is.
Okay.
He has to, as it relates to Mr. Demings, he has to turn it over. As if it only solely relates, if Ms. Liberty, if they're, I have no idea. If they say Miss Liberty went and did X, Y, Z with witness A, I don't know how that wouldn't be considered as relevant to the case. If they want to introduce that in the trial, you know, they're gonna have to turn it over within 20 days. So I think you're gonna have your answer in 20 days.
We'll see what the response is, and I'm sure we'll be.
So let me go back around to number one. Ms. Liberty, take your time. I needed the motion to compel that was related to the order that you're now seeking to enforce. This is back on motion number one.
Okay.
Judge Murphy granted a motion to compel on February 9th, 2024. You're telling me the motion to compel that I'm looking at is not the correct motion to compel. So I need to know the motion to compel that you believe Judge Murphy was addressing.
Okay.
What is the date?
February 9th.
Judge Murphy signed an order
2 orders.
February the 7th.
Yes, he did. Excuse me, no, Judge, I filed the motions the 7th, right? He filed orders on the 9th, docket entry 7071. They then, I believe, filed motions for rehearing, and then he filed additional orders saying.
Wait, what date did you, the motion to compel?
The motion-
That he's ruling on, what date did you file that?
February 7th, 2 of them.
Okay. 2024, so over a year ago, she filed these things. So don't act like you didn't know. Hey, another CG, good to see you. Welcome. Thank you for joining us. Ooh. Oh.
Law enforcement to serve Mariah Hamilton. And then number 2, email dated April 18, 2023. And then number 3, any and all emails between the State Attorney's Office and Christopher Barris to arrange Mariah Hamilton's appearance at deposition. Correct?
Yes, Judge.
Okay. And you're telling me the state has not just complied with this order? They have not disclosed those items to you?
No, they did comply. They gave sorry, I didn't ever get the 218. I didn't ever get that clarified until we did the deposition at Garrettsdale, and he brought them. The subpoenas, I had got an outdated subpoena, which looked to me an out-of-country warrant that was good for 90 days. That was issued sometime in 2020. I was looking for something that would have put her on notice of Mr. Demon's trial date that we had already conducted and or any depositions. I had asked for any attempts to locate her. I had reason to believe they can't find her. So I was just asking for whatever efforts were put there. They moved for a hearing. That was also denied a year later. If they don't have the items, as I put in my motion, file a response that we don't have these items in our possession or they don't exist. I am literally trying to box them into a statute that I, again, don't think they've met. It's vindictive, but I will take the steps to prove that if I have to.
So, you're talking about you need paragraph 1, proof of all efforts by law enforcement agencies to serve Mariah Hamilton with writ to appear at trial, including not only skipped races, searches for employers, searches for enrollment in college, trade schools, or other education. All efforts made.
Holmes as well as Ms. Hamilton.
He's a lawyer.
He's a lawyer.
Judge looks ultra confused.
What I think is a motion. Judge Murphy granted it, so Judge is trying to see what-
Judge, we have, and they also filed a response on February 9th, 2025, when the court received it.
February 9th, 2025, which case number?
It was filed yesterday.
It was filed yesterday, I'm sorry, the date on the notice says February 9th, it was filed yesterday. Filed case number 19-1872 CFNA.
So I didn't receive it, Judge. As a matter, I was up
Yeah,
this
I haven't
morning
seen it.
checking my emails.
So you want me to pause on this one since all these filings are just coming in, and in the interim, maybe you all can kind of resolve this between yourselves. It doesn't seem very complicated.
It's not, but
It's not, but.
So, Ms. Liberty, you want to take this one pending? I'll defer on it. I'll take no action today. It'll remain pending for our next hearing on all pending motions. You want to do it that way?
Yes, Judge, fair enough.
Okay, so that's all the matters that were noticed for today. I'll sign all the orders momentarily. Say, anything else that you need me to do regarding Mr. Dennis? I don't know what you're saying on it.
That guy's ugly.
if you want to address Friday's hearing before, we can have a moment then.
Friday, what's that?
Mr. Barris set a hearing for Ms. Hamilton this Friday, unfortunately.
Trial when the evidence is coming in, or can we do it pre-jury selection and get a preliminary ruling from the court where your rulings would be, it's not coming in or it is coming in, always subject to what the testimony may be?
I don't have any policy, okay, on these specific things.
So basically, they're confused as to why the judge won't make rulings on the motion to eliminate, and they're trying to clarify, and the judge doesn't have a policy.
On whatever you want, but, you know, my experience is that most of these motions are based on here's what the lawyers think the witnesses are going to say when they come to court. And the only thing that is consistent in every trial is whatever the lawyers think the witnesses are going to say when they come in here in court.
They don't.
I don't know what it is.
I'm talking more of a situation where the state wants to bring in evidence of what happened during the Civil War. I'm being absurd right now. I'm just saying that it has no bearing on the trial whatsoever. But they, for some reason, want to bring in what happened at the Battle of Antietam.
Okay, so the judge again pointed out that Melly has been in jail for over 2,000 days. He's been there for 6 years. He's an innocent man. Of course, the judge, can't control the appeals court and how long they take to make on their ruling about the excluded evidence. So, my understanding is the trial is going to be in September. That's it. They're going to go forward in September, and that's that. The retrial. So, we shall see. All right. In May, Cinco de Mayo is the first day of the Diddy trial. I am going to go to New York City. I'm going to sacrifice for y'all. I don't like cities. I don't like big cities, but I'm going to do it. I'm going to go to New York City, and I'm going to watch as much of the trial as I can. Hi, Nene. And so I am planning that trip soon. We're moving offices today, but probably sometime next week, in the coming weeks, I'll plan the Diddy. If anyone is interested in a meet and greet in New York, let me know. And then also let me know, like, where's a good location so that we can set that up. That would be really fun. I'm very, very much looking forward to the Diddy trial. It is going to be super interesting. And because it's the Fed, it should be way more organized than what we've watched together. Because we mainly watch state trials where the state government is prosecuting people. And you may have noticed they're not that good. You may notice a pattern. But the Fed don't come at you without receipts. Okay, the Fed's got the receipts before they come at you, period. So Diddy is going to be very interesting. Very interesting. So that's going to be in May. I'll be going out to NYC, and I will report to y'all, and of course observe, do whatever I can, and get back to you. I'm not sure of any interesting trials that are happening right now, so if there's any trials you want me to watch and recap for next week, just let me know in the comments. Give me a comment with what you want to see for next week, and probably there'll be a little more Melly. That case is such a mess. And I think that's it. I really appreciate y'all joining. Thank you for your likes, your subscribes, for your support on Cashapp. We're remonetized now, so all the support in the remonetization, I super duper appreciate it. Make sure you go to Instagram and follow us there. We're starting to kind of build a following. And on Instagram, we can show videos that we can't show. Okay, so head over to Instagram. Another CG, I will come to Cali as soon as there is a case there that interests me and interests y'all. Okay? And I'll definitely do a meet and greet from there. All right, thank you so much for joining me today. And for those of you that were with me during our verdict watch, thank you. That was so fun. Sorry my house was a mess. We're about to move my daughter. I moved offices, and then my daughter and I are moving houses. So sorry about that. But I appreciate you very much. And Tall Glass says Karen Reed has a big motion next week. Okay, we can definitely go over that next week, Tall Glass. Make sure you put in the comments whatever else you want to see. Thank you.